Hey everybody, Matt Barton here with this week's Broker Minute or Two. In the past month or so, I've had some version of this question asked 3 times, and the question is, hey Matt, can we write a purchase agreement with a undisclosed buyer? The short answer is, well, yeah, there's nothing illegal about that, but there are some really practical things that come into play. Let me start with this. When I first got this question most recently, I was like, you know what? I remember this being discussed, and as near as I can remember, this was like something that was discussed in your pre-licensing course, talking about commercial. And if a large entity like Amazon or Walmart wanted to buy some property, there may be some reason why you want to have an undisclosed buyer. And so that's kind of like the business case, or a celebrity maybe buying a property and they don't want people to know. Um, so the reason for it is understandable. And guess what? In the commercial space, I think this is probably something more common, partially because they don't typically use canned forms and have attorneys writing specific documents for specific unique properties. UAR, the Utah Association of Realtors, and the DRE does not have a form nor an addendum that I'm aware of, and I think I've searched pretty far and wide, that facilitates an undisclosed buyer. So if you have that situation where somebody is emphatic that they want to put an offer in, we are not to be realtors at law. So if it's something more than filling in a form, our standard go-to line would be like, yes, I can help you on that. And I'm even happy to recommend a real estate attorney. But if we're creating unique verbiage for unique situations, then we would want to employ a real estate attorney. In practical terms, when you think about this, especially when it comes to just residential real estate, if you were to successfully put undisclosed buyer, what's going to be the natural reaction of the seller? Yeah, you're right. They're going to be like, well, wait a minute. Why would somebody not disclose who they are? Who are they? If you put, for instance, the name of an entity, there are companies that are very good in a lot of situations discovering who the principals are in an entity, an LLC, or otherwise. The point being is you almost create more attention by putting undisclosed. Some people will go and have a trusted friend, acquaintance buy it in their name, and then later on transfer the property. But you got to be careful even with that, because there could be potential tax consequences depending on where the property or the transaction takes place. So coming full circle, the answer, if somebody asks you that, is yes, it can be done. Typically, it will require a real estate attorney to draft that, because the documents at our disposal that we have from UAR, from DRE, from our company don't really provide for that, because it's such a unique situation. I know that's not super helpful in how to do it, but hopefully it points out that it can be done, and the how to do it would be to have a real estate attorney help. There's a lot of information. If you are bored, need to have some go to sleep material, go Google online. You'll get stuff that's generic. It's not necessarily Utah specific, but it'll show you some of the significant consequences that can come about because of this. And so I think that's why UAR and DRE does not have a canned form that allows for that. I hope that helps. Hope you're having a great week and surviving the cold, and we'll talk soon.